Welcome once again to Lehto's Law. Here's Steve Lehto.
I am an equal opportunity critic. I will talk about any profession out here, even attorneys. And I remember a while back I did a couple stories about police officers. And someone sent me a note and said, Steve, I'm a police officer and you're always picking on us and you never pick on lawyers. There are bad lawyers out there. I talk about bad lawyers too. Case in point, today, Sean sent me notes and Steve checks out northcentralpa.com. Attorney receives 4-year suspension by Pennsylvania Supreme Court Disciplinary Board. Carrie Pauling wrote this about an attorney who's been suspended from practicing law for 4 years by the Supreme Court Disciplinary Board as a result of an investigation into misappropriating funds, lying to clients, and failing to act with diligence and promptness time and time again. Do something one time, you can kind of make it look like it may have been a mistake or an accident. If you do it several times, it starts to look bad. State police searched the attorney's offices in Hughesville, Pennsylvania back in January of 2017 after 2 employees went to the police with suspicions that the attorney had stolen money, maybe more than $100,000 from clients, according to a report by WNEP. Now, charges were not immediately filed after that raid, but on Tuesday, the Office of Disciplinary Counsel filed a joint petition outlining multiple charges against the lawyer. And by the way, this lawyer was also a former Bradford County Assistant District Attorney. The first charge, according to the ODC, was that the attorney was found to have misappropriated and spent all of the settlement proceeds her client had been awarded following a car accident. She was retained in August 2017 to represent a client. She helped to negotiate a $15,000 settlement and told the client that she would waive her own fees. So in other words, she negotiated a $15,000 settlement and said, you're getting all of it to the client. And according to the ODC court order, she explained to her client that the opposing counsel had asked her to hold the funds in escrow until the case had been dismissed. Her client endorsed the checks and gave the attorney sole control over that trust account that held the money. Now, the attorney would have had control of that trust account already, but she's saying she had permission to handle the money. Between January 2nd and January 8th of 2020, the attorney transferred, in increments, her client's settlement funds from the trust account to her business and operating account and told her client the paperwork had not yet been released. By February of 2020, the balance in her client trust account was 25 cents, and the balance in her business operating account was minus 900. So she got her trust account down to 25 cents. And her business account was in the red by $900. Now, I've mentioned this before, that attorneys routinely handle money for clients. So if I'm your attorney, and I settle a case on your behalf, and the money gets sent to me, I put the money in my trust account, and with your permission, and we talk about this. And then what happens is I cut you a check for your share, and I cut myself a check for my share. This is an extremely easy thing to figure out, because let's give that example again of $15,000. In a typical situation, let's suppose I got a third, you got 2/3. So $15,000 means I get 5, you get 10. This is simple. So the entire time that money is in the account, that account balance better never drop below 10 until I give you your money. And if it drops below 10, that means that I have by necessity mishandled your money. So when her client trust account drops to 25 cents and she owes somebody $15,000 out of that trust account, she has a problem. According to court documents, the client tried repeatedly to get in touch with her via phone, email, and even on Facebook, but the attorney would not return the messages. More than 2 years after the proceedings, her client had not received any of the $15,000 settlement. After being served with a letter from the ODC in June of 2022, she sent her client a $15,000 check, but she failed to produce other documents that the ODC had requested, including records of the bank accounts that she deposited the check into, bank statements from before the event until now, written communications, etc., etc. So she was found to have violated the rules of professional conduct by failing to provide prompt information, failing to separate her client's property from her own, keeping the client's settlement funds, and not keeping proper records relating to the case. And unfortunately, we've all heard of those businesses that operate sort of like a Ponzi scheme, where somebody's dealing with a series of customers, and they owe a customer money, but a second customer comes along and pays the person money, and then they use that money to pay the first customer. And there are industries where that happens a lot. I've heard of that happening, for instance, in the building trades, where somebody takes money and says, I'll pour your driveway. I'll put in a driveway for you next month. Give me some money. They get that money and they spend it. And so they don't have any money to actually begin the work when they're supposed to. But they sign up a second client for a second driveway that'll go in after the first driveway. And then they use the money from the second customer to pay for the first customer's job. And I've heard of that where they get several customers into it. But that should never happen with an attorney. Because like I said, the trust account is where the money's got to be, and the money's got to go from the trust account to the client. It does not go into the attorney's account first, then to the client. That's not how it works. Second charge was that a client reached out to the attorney regarding a children and youth custody case in which the attorney agreed to represent the man at a rate of $225 an hour, which would be drawn from a $2,500 retainer. However, she did not communicate the fee for representation in a second potential federal court case. So her clients paid her a $5,000 retainer on January 23rd, 2020 to cover both the custody case and the federal case. She deposited that money into her business and operating account instead of her trust account. And that's something that I've heard of happening before, where if a client comes to you and says, I want to hire you, I'm going to put some money down as a retainer, and then you can draw from that retainer as you earn the money, instead of sending the client a bill every month or something. Well, you haven't earned that money yet as an attorney when the person walks in and gives you the check for the retainer. You have to earn it by doing the work. So you're supposed to put the money in your trust account and then pay yourself out of it as you earn the money, all along the way documenting that and sending your client a note saying, oh, by the way, this month, here's the work I did, here's what it cost, and here's what I paid myself, and here's what's left in the trust account with respect to your retainer. So she was served papers from the ODC regarding this issue, and afterwards she sent a certified check to her former client, and turns out that was well over 1 year after she'd ended the representation, meaning that apparently she knew she hadn't earned the money, and so the money that she hadn't earned when the case ended should have gone back. Meanwhile, the third charge was she was retained in June of 2020 to represent clients in an immigration matter for a flat fee. Clients paid her in installments through February 21. As the payments were advances against legal fees and expenses, she was required to place them in her trust account. So trust account problems are something that happen quite a bit, and that again is what happened here. So for the third time, she was found in violation of the rules of professional conduct. I jumped over a lot of the details because they talk about what she did work when and how she billed her clients and whether she should have taken the money earlier or later. But she also has resigned her position as the Bradford County Assistant District Attorney. But the important thing here is that when attorneys get in trouble, there's a couple things that pop up over and over again. And I've mentioned before that as a member of the Michigan State Bar, I get a copy of the Michigan Bar Journal in the mail. Articles about the law, changes in the law in the state of Michigan, the rules changes from the Supreme Court, if any. In the back is a section on discipline. And you go through and you see what attorneys have gotten disciplined for. And problems with trust accounts and the handling of money is almost always in there. That's one of them. By the way, there's a few others. There's also the problem with attorneys who simply get in trouble with the law as they go about their daily business. Drunk driving, for instance. If an attorney gets busted for drunk driving and convicted, they got to go to the oversight people and tell them, yeah, I've just been convicted of a crime, and you might get sanctioned for that, even though it has nothing to do with your practice of law. But one of the primary things that you see in there is you'll see an allegation where it'll say the Supreme Court and the administration of the people who oversee the discipline charged an attorney with doing something wrong, sent the charges over, and no response was ever made. A hearing was held, no one showed up. So we are now going to just render our discipline, and it becomes the equivalent of a default. And the disproportionate number of cases that get resolved that way are indicative of the fact that some of these attorneys who get in trouble know they're in trouble. And as soon as they get caught, they're like, I'm done. Like there's not much you can do. So interestingly here, she was suspended for 4 years. And I've had people say, Steve, when an attorney gets suspended for 90 days, 180 days, 365 days, really? Like what happens? And so you have to understand, if you are an attorney and get suspended for 90 days, you have to notify all of your clients, if you have any pending cases, that, oh, by the way, I am not your attorney right now because I'm not licensed to practice law. My license has been suspended. And you actually are supposed to notify all your clients, let them know that. And if they have pressing legal needs, they have to go find somebody else. And that, of course, would be the big issue. And so I've heard of attorneys who had very, very large caseloads who got suspended and had to, sit there and hammer out all these letters saying, just to let you know, I've been suspended. I'm no longer your attorney. And there is a time, it depends on what state you're in, but there's a length of time for which, if your suspension is that long or longer, it's the equivalent of you letting your license lapse. And so, as you can imagine, to become a lawyer, you've got to do all the stuff, character and fitness, take the bar exam, got to pass the bar exam, and get admitted. So if you let your license lapse, you can't just go, oh, I've changed my mind, I want to become a lawyer again, just pay the money. You actually have to jump through all the hoops back at square one. So it's quite possible that a 4-year suspension means that after that period of time, if she wants to be an attorney again, she may actually have to jump through a whole bunch of hoops, almost as if she had never been an attorney in the first place. So I don't know what that length of time is in Pennsylvania, but that is another issue. So I know people who, when they are in trouble in a situation like this, what they fight over is whether or not the suspension is going to be long enough to actually force them to go through all those hoops again to become an attorney, or if they'll simply be able to reapply. And by the way, many of these things will say you're suspended for 90 days, after which the suspension will automatically lapse, and then you'll be able to go back and practice law. Others say you will be suspended, after which, if you want to be readmitted, you must come back, petition for readmission, and explain why you think you are now fit for the practice of law when you weren't fit just shortly ago. And so you may have to go through all kinds of hoops. So get back to the example of if an attorney got busted for drunk driving and somehow that suspension that resulted was long enough to jeopardize his legal career or her legal career, you then have to explain how that was an isolated incident and the treatment you've gotten and so on and so forth, and how it's not going to happen again. That's probably a situation where there's a very good chance that you'd be able to practice law again. However, if you were busted several times for mishandling client funds, very, very large amounts of money, there's a very good chance they're going to say, well, gee, you did it more than once. And in fact, there were 3 counts against you last time. What makes us think that you're not going to do that again? So we'd have to wait and see what happens. But as of right now, she's received a 4-year suspension from the Pennsylvania Supreme Court Disciplinary Board. And as I've mentioned before, keep in mind that the courts of most states are run by the Supreme Court, including how the attorneys are licensed and governed and disciplined. So that is up to the Supreme Court. Now, whether they have a separate board that handles that or if they appoint people to handle it, how that works, it's going to vary wildly from state to state. But the Pennsylvania Supreme Court Disciplinary Board has deemed it appropriate for this attorney to be suspended for 4 years. North Central PA reported it. Carrie Pauling wrote it. Sean sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. When things aren't adding up in your life, start subtracting.